Good morning. For those that have connected, we're going to start the broadcast or the webinar in a few minutes. We're just getting everything ready so you can all connect, and we'll start at about 10 o'clock. We've got a minute or two to go. Okay, good morning, everybody. It is 10 o'clock, so we're going to go ahead and get started with the presentation. As you know, my name is Sara Costanzo with Weltman, Weinberg & Reese, and I want to thank the Northeast Utilities Collections Group for inviting me to speak on this topic today. We're going to talk for a half hour about the CARES Act, the Coronavirus Aid, Relief, and Economic Security Act that was just signed into law about a week ago, and the specific provision within that act that impacts the Fair Credit Reporting Act and how utility providers and potentially their vendors are impacted based upon that legislation. I do want to welcome you to our webinar today. Make sure that your phone is muted so that there's no background noise to disrupt the presentation. It is being recorded. You can type your questions in the questions feature over on the right-hand side. Those questions will be answered at the end of the presentation. I may answer some throughout if they're posted, if it pertains to a particular topic that we're talking about at that moment. And then again, we do plan to conclude the session within a half hour. I will allow some time for questions. So for today's overview, we're going to be talking obviously about the Fair Credit Reporting Act, a little bit of the history there, the CARES Act, what it is and how it will impact data reporting, and important changes for utilities and your vendors that you need to know about, and then the implications on the dispute process, as well as the lovely word liability. So again, we'll have time for questions and answers at the end. So first of all, the Fair Credit Reporting Act is found in the United States Code 15, Section 1681 et seq. So it's a very large act. It was started in 1970. It's been amended several times since then. The two largest amendments were the Consumer Credit Reporting Reform Act in 1996 and the Fair and Accurate Credit Transaction Act of 2003. The purpose of the act is to promote accuracy, fairness, and privacy of information in files of consumer reporting agencies. The rights of consumers in part, and I've highlighted two of them that are important for today, obviously access to a credit report, protected access, accurate reporting, which we'll talk about, having outdated information removed, protecting personal account numbers, receiving notification of negative information, and their ability to seek damages. So those two important ones, accurate reporting and the ability to seek damages. So how does that relate to you? Well, you as a utility provider are potentially a furnisher of information, and you are a furnisher if you are a person or a business who furnishes information to consumer reporting agencies. Some utilities I know do directly furnish information. Some utility providers require their vendors to furnish credit information of theirs to consumer reporting agencies. As a rule, it's illegal to report information that you know or believe is inaccurate or you believe is inaccurate. And what you have to look at is whether you have reasonable cause to believe that information is inaccurate, and that would be if you have knowledge other than just allegations from the consumer that would lead a reasonable person to doubt the accuracy of that information. So there's two things that are important here. Furnishing information that is accurate and complete, so that's your obligation. And number two, investigating consumer disputes about the accuracy of information that you provide. So you can be exempt from the requirement about reporting potentially illegal information if you give an address for consumers to report inaccurate information, but certainly not recommending doing that because, again, you cannot under any circumstances report information that a consumer has told you is inaccurate. You do have the requirement, we'll talk later on about including in a report anything that's disputed if it hasn't yet been investigated or established to be either accurate or inaccurate during that time. So other obligations as a furnisher, you are required to have written policies and procedures regarding the accuracy and integrity of information being furnished. So if you don't currently have written policies and procedures, that's going to be a red flag number one, and we can talk offline about how to remedy that, but that is actually a requirement under the Fair Credit Reporting Act. So if you're furnishing information to credit reporting agency, you must include the following items that are applicable. So there's several things, but these are the two that I felt were important for today. One is when you have a closed account, who actually closed it? So did you as the creditor close the account? Maybe it was paid, maybe it was disputed or settled, or did the consumer close it where they actually resolved their balance with you and they chose to close the account for whatever reason? That has to be distinguished on anything you're reporting for closed accounts. And then delinquent accounts, which is the bigger category here. So you must report the date of delinquency to the credit reporting agency within 90 days. And that date traditionally is the month and year the consumer's delinquency resulting in the referral began. We're going to talk in a few minutes about how the CARES Act kind of changes that a little bit and may be problematic after the pandemic is resolved, I'll call it. But right now, keep in mind that you would normally report the month and year of the consumer's delinquency when it resulted in you reporting or referring the account. You also have to have, other than written policies, if you have a vendor that is doing your reporting for you, you have to have a copy of your vendor's written policies and procedures. So either you have to have the written policies or procedures, or your vendor does. And within those policies and procedures, I'm going to list a few things that are required. They must be appropriate to the nature, size, and complexity and the scope of your activities. They must be reviewed periodically and updated. You have to keep records as to how often you're updating those or revising them. You have to ensure the information provided to a credit reporting agency is for the right person and reflects the terms of the account and their performance on the account. It requires maintenance of records for a reasonable amount of time. You have to establish internal controls for accuracy and integrity of information, such as through random sampling, and that also becomes important when we talk in a little bit about disputes. You have to prevent the re-aging of accounts or duplicate reporting. It requires updating the furnished information where necessary. And that information should be, again, substantiated by your records. When it's furnished, include consumer identifiers like their name, date of birth, social, telephone number, or address, some type of demographic included, and then be furnished in a standardized form and specify the time period that it relates to. So those are things that have to be included in your written policies. If they're not, again, we can talk offline about that, but that is actually required under the Fair Credit Reporting Act. Any questions on the Fair Credit Reporting Act? All right, so we'll still talk about it, but I want to hop over to the CARES Act and give you some information there before we kind of do the blended piece of them both. So the CARES Act, I think I put the wrong citation in there, so I apologize, but the purpose is to provide credit protection with respect to Section 4021. So the CARES Act itself is about a 1,000-page act that, again, was signed into law about a week ago, but there's a specific provision under Section 4021 that pertains to the Fair Credit Reporting Act. So this is where we see credit protection during the COVID-19. So during this pandemic, there's specific rules that we'll talk about. And in the CARES Act, there's $2 trillion of economic stimulus being provided to the economy. So again, that was signed into law on March 27th. So the important changes to the CARES Act for fair credit reporting is specifically Section 623A1 of credit reporting is modified. So this slide and the next slide actually contain the exact language from the CARES Act. So it's not modified, it's in exact format. So the section that's modified is reporting information during this pandemic. So we talked a few minutes ago about, when someone is delinquent, if you're reporting, there's certain key data points that have to be included, which highlight the day of their delinquency or when their delinquency started. So this you'll see modifies that a bit. So an accommodation is basically a payment modification, if you will. So it includes an agreement to defer payments, one or more. So if someone calls in and asks if they can skip a payment, maybe they can't make their April bill payment, they want to make a partial payment, if they want to forbear any delinquent amounts, modify any contract or any other assistance or relief granted to a consumer, so that's really broad, who is affected by the coronavirus disease pandemic during the covered period. The covered period, oddly enough, goes back in time. We don't see that very often, but it goes back to January 31st of this year, and it ends at the latter of either 120 days after the enactment of this subparagraph. So what that means is from March 27th, 2020 at 120 days, so that's the first window, or 120 days after the pandemic ceases to exist, when it terminates. So if the pandemic goes beyond the next 120 days, then obviously this section of the CARES Act remains in full force and effect. Covered period is extended, but at the smaller window of it, if it were for some reason to be declared done tomorrow, it would still go past. So the smaller window is 120 days after March 27th. The larger window will be 120 days after the termination of the pandemic. So it could be a pretty long stretch of time. Now that we understand kind of the time frame that we're looking at, then the next slide we'll talk in depth more about what does that mean. So when you're normally reporting a delinquency, a non-payment, or something like that, again, you're going to do it, include the date of the delinquency. However, if you or your vendor are making type of an accommodation with respect to the first provision, which is, any type of payment or modification, and the person makes the payment, so they may not be making the required payment, which in non-pandemic time, if someone paid less than what was due, they might get a ding on their credit report, right? You might report something as not being paid according to the terms or not being paid timely, but in this case, if they're doing this during the pandemic, that does not count as a delinquency. If the consumer is not required to make one or more payments pursuant to the accommodation, the furnisher, to be you or your vendor, shall report the credit obligation or account as current. So that's something very different. Normally, if you were doing a payment plan or some type of modification, you would not be reporting the obligation as current. But if it occurs during this pandemic period, the covered period, you will report the credit obligation as current, or this is the first twist on it, if the debt was delinquent before the accommodation. So if they haven't called in yet and they already were delinquent with you, then you can maintain that delinquent status during this period in which the accommodation is in effect. So this really applies to people who were current up until now. Now they're calling and asking for some type of forgiveness or payment accommodation, and that's when you can't report that during this period. If the consumer brings their credit obligation or account current during this period, you have to report the credit obligation or account as current. So if they stick with it, they get it back current during this pandemic period, then you would have to report them as current. So the exception, again, here in numbered paragraph 3, this above shall not apply with respect to a credit obligation or account if the consumer account has been charged off. So you have two different ifs. If they were already delinquent, you're not to change their status, or if you've already charged their account off, then you don't have to do this. So we're looking at people who were making payments, they hadn't been charged off, they weren't yet delinquent, but if they ask for assistance during the covered period, you have to make sure that you are still reporting them as current, not reporting them as delinquent. I know that's a lot jumbled into 2 slides, but that's the entire section of the CARES Act that applies to the Fair Credit Reporting Act. So you may ask, what exactly does that necessarily mean to you? What you have to do is distinguish between COVID payment plans, so from January 31st of 2020 through either July 27th or 120 days after the pandemic terminates as your COVID payment plan, so that you're not reporting those people any differently than you were prior to the covered period. And then your second category would be non-COVID payment plans. If they were charged off and want a payment plan, if they were already delinquent and want a modified payment plan, then you get exclusions there. But if you have a COVID payment plan, they weren't currently delinquent and hadn't charged off, you have to treat those differently, and you have to maintain that data, because as we'll go back to what the Fair Credit Reporting Act otherwise says, when you're reporting delinquencies, you're going to need to remember whether or not they were delinquent during this time or not, and try to identify the true date of actual delinquency. So how does that impact you as a utility provider? The question really is whether or not you presently report to the credit reporting agencies. So the 3 ones most people know about are Equifax, Experian, and TransUnion. There are other credit reporting agencies out there. There's, I believe, according to the FTC site, right around 25 other smaller agencies that do credit reporting, but these 3 are the primary. So if you in fact report to them, you're going to have to modify what your records are with respect to date of delinquency and whether or not they're in their covered period under COVID. And then if you don't, but you require any of your vendors to do that reporting, you still will have to adjust your records again so that whatever you're transmitting to your vendor will identify whether or not a delinquency occurred during the COVID period only, so it can't be reported as delinquent, or whether or not they were delinquent or charged off prior to the COVID period and maybe had a modification or further delinquency during that COVID period. So those are the 2 kind of areas where it's extremely important that you're going to have to modify what records you're keeping so that that is maintained in their file from now until, let's say, 7 to 10 years based on the time period on which you report to a credit agency a delinquent obligation. So the important changes or implications for the dispute process is the next area that we'll talk about. So if a consumer reporting agency or the consumer notifies a furnisher, so either you or your vendor, that the consumer is disputing the information, the furnisher, whether that's you or your vendor, has to investigate the dispute and review all relevant information, report their findings back to the consumer reporting agency. Even if the consumer is the one that disputed it, you still report to the consumer reporting agency. Provide any corrected information to the agency that received that information for investigation, and modify the information, delete it, or permanently block it, depending, of course, on what you found or couldn't find. The important part on that, again, is if their dispute stems upon whether or not they were delinquent during the COVID period or whether or not that should have been reported as a delinquency, you will need to have specific information that you can rely on for that. There has been case law that specifically addresses areas where you can't just, as far as your investigation is concerned, you cannot just go back to your records and say, well, it looks accurate, we see the billing statement, we see the service address, and we see that the monthly invoices equaled that, so we're good. That's called data conformity, and the data conformity rule, as a matter of law, has been found by the courts to be inadequate. You actually have to do more than that, than just looking at your method of garnering data and method of reporting and capturing the data, you have to actually have some records to be able to pull that up. And again, this is why your record keeping is important right now, so that you can identify, was this COVID during the covered period? Was it not? Were they delinquent prior to this? Or were they charged off prior to this? And if you don't have those records, you're probably not going to want to have your vendor or you report those individuals, because you would want to err on the side of caution, not get in further trouble if you can't maintain records so that when there's a dispute, you have enough information to validate or invalidate the dispute. So the furnisher, you or your vendor, must complete these steps within the same time allowed under the Fair Credit Reporting Act for an agency to resolve the dispute. It's normally 30 days once they get a dispute from a consumer to investigate and provide that information back. So if it's from the consumer reporting agency, they have to give you all the information that they've gotten within 5 days, and then promptly give additional relevant information if the consumer supplements their dispute. If you don't investigate and respond to the notification of the dispute within that 30-day window, then they have to delete that record from their data files. So if you want it to stay on the person's report and you believe it to be valid, you have to get back to them within 30 days or it gets deleted. You must investigate the dispute if it relates to their liability on a credit account or other debt with you. The terms of the credit account, so again, if you gave them an accommodation or a payment plan, the terms of their account or debt, their performance, did they make the payments required as modified, or their contact with that account, and any other information in a consumer report about the account or relationship with you that affects their creditworthiness, credit standing, credit capacity, character, their general reputation, etc. So those are the things that are important with respect to what you're investigating, and whether or not it could be something that is considered to be a frivolous dispute. So again, the biggest thing to look at is the impact from the CARES Act is the date of delinquency for you guys. So this slide summarizes again what you do and don't have to do. So you do have to conduct a reasonable investigation, and that can't be relying on just your data conformity. You have to review all relevant information provided by the consumer, report the results within 30 days back to the consumer reporting agency or agencies, and notify the agency whether it's inaccurate or needs to be removed. Do not have to do any of the following. Those are things that are not required of you, but I just listed those because sometimes people think you have to do that, but that is something that's not required. So those are your do's and don'ts. So the scary part, liability. Whether or not you do what you're supposed to be doing under the Fair Credit Reporting Act, understand that you can actually be sued by not only the consumer, but you can be sued by the Federal Trade Commission, and you can be sued by the CFPB. You can be sued by one of those three. You can be sued by all of those three. And if you are, watch out, because they can be pretty unrelenting. So any person who willfully fails to comply with any requirement imposed under the Fair Credit Reporting Act with respect to any consumer is liable to that consumer, and this is if the consumer pursues you, in an amount equal to the sum of, and the first parts aren't too bad, any actual damages, not less than 100 but not more than 1,000, and this is per violation, or in the case of liability of a natural person for obtaining somebody's report under false pretenses, so not having a permissible purpose, $1,000 or whatever damages that person sustained as a result of you improperly pulling their credit report. So that one could be larger. The bigger pockets are the next two. Such amount of punitive damages as the court may allow, and we see in the headlines oftentimes the courts are really harsh when it comes to these types of punitive damages, and, so it's not an or, it's and, in the case of any successful action to enforce any liability under the Fair Credit Reporting Act, the costs of the action together with, the magic word here, reasonable attorney's fees, and then as determined by the court. And that's the big motivating number there, because there's no cap on reasonable attorney's fees. So a court can issue attorney's fees if you end up getting certified into a class action because they feel that you haven't complied with the Fair Credit Reporting Act. that you've misreported delinquency dates under the covered period under the COVID pandemic, you can really subject yourself to some pretty mounting debt. The Fair Credit Reporting Act does provide for a maximum of penalties if you're pursued by the Federal Trade Commission. So if the FTC sues you, so what we just went over was when a consumer sues. If the FTC decides to come after you, your maximum penalties, that's not anything else, just the penalties per violation is $4,063. I have no idea why it's a weird number, but again, per violation. So if they were coming after you for multiple violations, that $4,063 can add up pretty quickly. So what are your defenses? Defenses, obviously, you can rely on a good faith defense to show that you didn't report this as willful. However, there are cases that say that if you are reckless, that reckless can be deemed willful. So you have to be very cautious here. So you must perform as careful as an inquiry as reasonably necessary to resolve a consumer dispute on the merits. So again, we can't rely on did your data conform to what your system thinks it says. You actually need, when there's a dispute, to dig into the depth of that particular account and file, keep records of what you did to investigate the dispute, to report that back. So the two areas in my understanding of the CARES Act and Fair Credit Reporting Act as it hits your front are the date of delinquency during the covered period and making sure that you are correctly responding to any consumer dispute that would probably likely hinge on whether or not you're allowed to identify their account as delinquent and what is the original date of delinquency. Those are the two areas that, again, you can see the text of the statute. It only takes up 2 slides because it was just signed into law on the 27th of March. There's obviously no case law and no legislative opinion or legal history to dig into this particular section to see what their intent was. That will play out, I think, after the conclusion or the termination of the pandemic. But these are kind of the weak areas, the way this is written, that give some exposure to you and your vendor as furnisher of credit information. The statute of limitations on these claims is also a moving target. It's the earlier of either 2 years after the date of discovery by the plaintiff of the violation, so by the consumer. So when the consumer discovers that this is on their report, and not everybody pulls their credit report once a quarter, so it's once they discover it, they have 2 years to file an action against you as a furnisher or your vendor, or 5 years after the violation date occurred. So if you improperly reported or failed to address a dispute, 5 years from that improper act would be the end of the time period from which they could pursue you. That's your statute of limitations. So it's thankfully the earlier of those two things. So the longest period you would have really is the 5 years. All right, so we are at the end of the session. I do have a couple slides at the end that talk a little bit about our firm in case you don't already know about us. They're there for your review. I won't read them to you, but I do want to allow you some time to ask me some questions. You can type them again into the side. The first question we have, I see posted here, is, as a utility, how does this impact us that use outside third-party agencies to collect? So again, the collection isn't what the CARES Act for utilities is necessarily addressing. It's the reporting, the Fair Credit Reporting Act. So whether you're the one that's collecting or whether your vendor is collecting on behalf of you, you have to make sure, are you doing the reporting or are they doing the credit reporting for you? How are they doing that reporting? If you've assigned a charged-off account to your vendor, you have that exception to the rule with respect to reporting during the covered period. If, however, you have an agency doing first-party collections for you and you haven't charged the account off, then you also have to be careful. Now, that's currently, but if you have an account that's in your utility now that next year charges off and you're assigning it to your third-party agencies to collect, have you maintained sufficient data so that normally you would transmit to your vendor the service address and the dates of service. When did they start service? When did you terminate service? And date of last payment, or that's essentially when they became delinquent, when they last paid you. What's important is, are you capturing the data as to, did that delinquency occur before the COVID period or during the COVID period? And if they were current all the way up until the COVID period, then you can't treat a modified or missed payment during the COVID period as a delinquency. You would have to wait until the end of the COVID period. If they're still delinquent and didn't cure that delinquency during the COVID period, then you can only report them delinquent after that period. So that's the biggest impact on your outside third parties. They're relying on you to capture that data, maintain that data, so that when you transmit files to them, they have the accurate information as it's somewhat modified based upon the covered period under COVID. All right, I don't see any other questions posted. I'll give you guys another second if you aren't typing as fast as I might be talking to see if you have anything else to submit. If you don't think of anything right now, but later a question comes to mind, please feel free to reach out to me directly. I'll certainly answer any questions that you have, and I'm happy to help out. Again, I really appreciate the NEUCC asking me to present on this topic today. And again, this is just one small sliver of what the CARES Act covers. This is just the provision addressing fair credit reporting. Okay, so there was a question here. Can I talk more about the 120 days after the pandemic ends? So again, the 120-day period is what's called the covered period under the Fair Credit Reporting Act, under the CARES Act, Section 4021. So the period of time within which the person can't be reported as delinquent unless the two exceptions apply is from January 31st, 2020 until the latter of either 120 days, which takes you to July 27th, or 120 days after the date at which the president declares the pandemic terminated. So if the pandemic becomes terminated sometime earlier, you're going to take that date, of the effective date of that order, and add 120 days onto it, and that's allowing the consumer another 120 days to continue with any accommodation or modified plan and get their account current. If they don't get their account current by the end of that period, you can then report them as delinquent, and the delinquency would start then, unless they had been delinquent or charged off before January 31st, 2020. Okay, I think that's the only questions that were posted. So again, if you have other questions after the webinar, please feel free to get a hold of me. I appreciate you guys giving me the opportunity to present to you, and of course the time that you spent this morning with me.